Welcome to BusinessTraining.com. The following video module focuses on the Health Insurance Portability and Accountability Act. This is our agenda for the video topic today. Please take a moment to review the outline. The Health Insurance Portability and Accountability Act is a federal law that was enacted in 1996. HIPAA ensures health coverage and privacy to patients in an age where paper documentation of medical and health records is being replaced with digital documentation. HIPAA is split into Title I and Title II. Title I deals with healthcare access, portability, and renewability for workers and their families when they change or lose their jobs. Title II prevents healthcare fraud and abuse, administrative simplification, and medical liability reform dealing with the establishment of national standards for electronic healthcare transactions. HIPAA has many effects on the healthcare and insurance industry and applies mostly to covered entities such as medical providers, health insurers, or healthcare clearinghouses, but we will focus primarily on the key points of HIPAA and its effect on employers. Title I of the Health Insurance Portability and Accountability Act regulates the availability of group health plans and individual health insurance policies. It amends the Employee Retirement Income Security Act, the Public Health Service Act, and the Internal Revenue Code. The purpose of Title I HIPAA is in that it ensures that group health plans cannot deny coverage or establish a monthly premium that is based on an individual's or their dependent's health status, which includes medical history, genetic information, or any disability they may have. Title I also limits the restrictions that are placed on benefits relating to a pre-existing condition for 12 months after enrollment in the group health plan, or up to 18 months for late enrollers who miss the open enrollment season. The 12-month exclusion period is a maximum, though it may be reduced if there was credible coverage prior to enrollment in the new plan, and the reduction is based on the amount of time the coverage was offered. There must not have been a significant break in coverage of more than 63 days at any given time, however, to qualify for the reduction. Be aware, however, that individual states may be more stringent on their break in coverage policy, increasing the break minimum to more than 63 days nevertheless. Title II of the Health Insurance Portability and Accountability Act ensures the efficiency of the electronic information systems concerning healthcare transactions every year. Title II has specific administrative simplification rules that are issued by the Department of Health and Human Services. The first rule is a standard for electronic transactions. This is a national standard for electronic healthcare transactions that is meant to ensure that all processed health information uses the same electronic format so that an individual's health information can be shared, when authorized, with providers across the country. The next rule is the Unique Identifier Standards, which creates a national provider identifier for healthcare organizations and providers to reduce confusion and error. The security rule and the privacy rule are probably the two most important rules that will apply to employers. The privacy rule in particular is the most common rule that is thought of when speaking of HIPAA. The security rule ensures security safeguards are in place to protect each individual's electronic protected health information, or EPHI. The privacy rule ensures that physical, technical, and personal safeguards are in place to protect any and all personally identifiable health information, or PHI, in any form. That is paper, electronic, or oral forms. PHI is everything concerning medical information on an individual, including personal and family medical history and status, current conditions, as well as genetic information. Finally, the enforcement rule provides liabilities to violators of HIPAA and includes civil money penalties. How does the Health Insurance Portability and Accountability Act affect employers? HIPAA limits the ability of an employer health plan to exclude coverage for pre-existing conditions. It prohibits additional opportunities to enroll in a group health plan if coverage has been lost due to other events. It prohibits the discrimination against employees and their dependent family members based on health factors that they may have, such as prior medical conditions, previous claims, or genetic information. And lastly, it guarantees that individuals will have access to and can renew their health insurance policies. HIPAA does not prevent an employer, supervisor, or HL professional from asking for a doctor's note or health information that may be required for sick leave, workers' compensation, employee wellness programs, or health insurance. An employer cannot ask a healthcare provider directly for information without the employee's authorization or consent, And although normally a covered healthcare provider is required authorization to disclose information to an employer, they may be required by other laws to provide disclosure without it. HIPAA, however, does not require employers to provide any sort of health coverage, nor does it guarantee that any conditions individuals have now or have had in the past are going to be covered under an employer's health plan. HIPAA does not prohibit an employer from imposing a pre-existing condition exclusion period of no longer than 12 months or 18 months for late enrollers if the individual has been treated within the past 6 months. It also does not force group health plans to offer specific or certain benefits. An employer may not be considered a covered entity, as healthcare providers or healthcare clearinghouses may be, but they may find themselves handling personally identifiable health information that's protected under HIPAA, particularly when providing a self-insured health plan or acting as an intermediary between employees and the sponsored healthcare providers. If employers are a covered entity under this situation, they must adopt PHI privacy and security procedures and ensure HIPAA qualifications to maintain sensitive and confidential medical records. The privacy rule does not protect employment records and any files that may be included in employment records, nor does it generally apply to the actions of an employer or manager. When in doubt, anytime an employer deals with medical data or personally identifiable health information, it would be best to handle it under the privacy and security rules of HIPAA and only allow HIPAA-certified personnel to manage the data. If you would like more information on the Health Insurance Portability and Accountability Act, please go to the Department of Labor website at the following link. Thank you once again for your time and attention, and this is BusinessTraining.com, where you can earn a master's level qualification to make more money.